Hi, everybody. My name's Bobbi Reilly. I'm one of the co-directors of Global Training and Professional Development, and we welcome you to our Lunch and Learn series. Today, really excited. We've got a wonderful guest speaker that I'm sure you'll have a lot of fun with. Anne-Marie and I have been talking about this for a little while now. I think it started at the FRSA conference mid-year, and we've been talking about, I guess, the intersect with domestic and family violence and mediation and what we need to know as practitioners and how we manage all of that. Something that both of us are very passionate about. But for anybody who isn't aware of Anne-Marie, and I don't know that there'll be anybody on that isn't, but just in case, I'll just let you know a little bit about our wonderful guest speaker today. So Anne-Marie is the Senior Judicial Registrar, and she is also a multi-award-winning lawyer, accredited family law specialist, accredited mediator, and arbitrator and registered FDRP. Anne-Marie began her career as a legal associate in the Family Court in 1998 and has been a prior executive member of the Family Law section of the Family Law Council of Australia, a former member of various Queensland Law Society committees, including the Specialist Accreditation Committee and the past Flipper Queensland Vice President. She joined the courts in July 2020 and as a senior member of the leadership team is responsible for the expansion of the court's dispute resolution programs and registrar work progress practices. Anne-Marie has been delivering local, national and international keynote addresses, conference papers and workshops to lawyers and non-lawyers for about the last 20 years. She has a philosophy that conflict can be resolved without combat, and I really love that, and I think it really focuses in on what we're really focusing in at GPD. During her acceptance speech, after being named the 2018 WLAQ Woman Lawyer of the Year, in which she spoke of the exhaustion of the singular aggressive approach to legal practice, she became an industry and social media sensation. Anne-Marie has taught the undergrad family law subject at UQ for many years prior to joining the court, and she still continues to teach the postgraduate mediation and conflict management course at UQ as well. So thank you, Anne-Marie. It's a wonderful pleasure to have you here.
Thank you, Bobbi. It's lovely to be here today talking to you all.
And I think there's a lot of us as practitioners that have so much to learn around domestic and family violence and mediation and how it all fits. And we would really love your insights into that today. I know for myself, back when I became a mediator in 2006, I went through all of the normal trainings and learn about domestic violence and thought I knew a lot of things. And then I was very fortunate to be one of the lucky chosen ones to be a coordinator for the CFDR pilot, which was the Coordinated Family Dispute Resolution pilot. And that ran for a couple of years. And my understanding is it was the first time that domestic violence and mediation had really had a close eye over it. And we were trying to find safe outcomes for children through a mediation process. So for me, that taught me things that I didn't know. And it also showed me that as practitioners, we need to have a really good understanding of domestic violence. We need to have really good instincts when it comes to domestic violence and our practice as mediators, as well as a capacity to be able to manage those power dynamics and the domestic violence that is present in a lot of our work. So, Anne-Marie, I thought I would start the conversation with us by finding out from you what your perspective is around how common the intersect between DV and mediation is from your perspective.
I think one of the things to understand when you're working as a mediator in relationship breakdown context is there is likely to be at least an undercurrent of dysfunction in the relationship, if not really concerning elements of domestic and family violence, including coercive control. Yeah. There's an often quoted statistic from the Australian Institute of Family Studies, AIFS, that says about 80% of separating parents do not come into contact with lawyers at all at the time that they negotiate their outcomes. But for those of us who are working with the 20% who really need assistance in order to come to resolution, I think you have to be very mindful that there are likely to be risk factors present. And if you then look at the really pointy end of that dynamic, the matters that come before the court, there are some really concerning risk factors at play. And I'll just give you a bit of an overview about what we've learned about that in the court. And I was interested in you saying, Bobbi, what you thought you knew before you started really looking at this work. And I think that's a sign of longevity and maturity as a practitioner. When I joined the court, I'd been a practitioner for over 20 years and I really thought I'd seen everything in family law. But I have learned so much about risk, family violence, the interplay of that really challenging power dynamic that exists within coercive control. And what we have gathered from the court is then information that parties provide to the court through the mandatory notice of risk that now must be filed with every parenting application. And that document requires both parties to identify whether or not there has been family violence, whether that's against a partner or in relation to a child abuse, drug and alcohol use that represents a risk of harm, poor mental health, risk of abduction, threats of harm. So 5 main criteria. In the 2023 financial year, 91% of applications that are filed in the court have one or more of those risk factors present. 91%. That's an increase from the 2022 financial year. And it's not clear whether there's an increase because practitioners are getting better at identifying issues, parties are feeling more comfortable raising issues and the knowledge that the court's going to be responsive to them, or whether there's been an actual increase. 91% one or more of those risk factors. But this is the statistic that actually gives me goosebumps every time I say it, and I say it a lot. 70% of matters have 4 or more of those risk factors present.
Oh my God.
70% have 4 or more: family violence, drug and alcohol, mental health, abduction, risk of harm.
Wow.
So the idea that you would be working with a family that has no risk dynamic that you as a mediator need to A, be aware of, and B, manage is deeply naive, even if those parties are users of legal services, because that's the families that come to the FCOA. And we also know from the notice of risk that the most frequent type of risk factor that's identified is that a party has experienced family violence. 83% of those matters which allege a risk say it's family violence against the partner. 77% say it's family violence against the child. 72% child's at risk of abuse or has been abused. Interestingly, it's the recent threats of harm. Only about 25% of cases have that factor. The ones that are meeting that top 4 are family violence, mental health, drug and alcohol abuse, creating a risk of harm to a child.
Wow.
In a tragic way, that makes sense. These are the families that need the help of professionals. They will have risk factors present. And what's also so important when you're mediating is that risk changes during the life of negotiations, and it is that moment where you might really be poking the bear in that dialogue, where you're really going to need to be conscious of whether or not you are triggering risk or exacerbating risk by the very negotiation process itself.
Absolutely. And as you're talking, Anne-Marie, like I'm thinking about, we've obviously got pre-filing and post-filing, and these are the stats for post-filing. So that means that probably almost every single one of those cases has gone through pre-filing, unless of course they've applied for an exemption, but most of those would have gone through pre-filing, where I think as a practitioner, I'm like, if we're not asking the right questions, the court have this information because they're asking the right questions. But as pre-filing mediators, if we're not asking the right questions, we don't necessarily know the extent of the risk, and therefore how are we managing it? How are we managing that successfully?
So crucial, because we know there's much research surrounding the idea that victims of family violence, victim survivors don't disclose, particularly if they're in a negotiation context with the alleged perpetrator, unless they are really carefully encouraged to give that information. And I think all of the mediators who we have here today will have worked with parents who don't know that what they're experiencing is actually family violence, and that it's a dynamic that is so familiar to them because of their family of origin and the relationship that they've been in, that an ability to articulate the level of dysfunction and risk that exists for them is a really, really big ask.
Yeah, absolutely. And those people that are on with us today, please feel free to chuck some questions in the chat or into the question and answer box. We would love to hear your views as we're having this really important conversation. And I think, Anne-Marie, during my time as a trainer, I often hear about practice afterwards about people and what they're doing in the industry, because obviously I have access to a lot of mediators as they're sort of coming through, and kind of in some ways keep an eye on without meaning to people's careers, because people talk about people as they do. And I know, thinking about these risk factors and us making sure that we are asking the right questions to get the right answers, to make sure that we are keeping people as safe as possible through a process that is going to create so much upheaval in their life, which obviously makes them extremely unsafe at times. For you, how important is intake and the complexity of us, or the nuances of us ensuring that we're doing intake well? Because I know that there are some practitioners who kind of just tack it on at the beginning of the day and all of those sorts of things. And I have a very strong belief system about that, but I would love to hear your views on how that should be held.
I had a visceral response then, Bobbi, when you said there are some practitioners who tack it on at the start of the day.
Mm-hmm.
Mediation will fail without a solid intake. And I don't mean that means that you won't get to a result. You might well get to a result. But the stickability that goes with that agreement that's dealt with on a superficial level is very different to one that has really addressed as many of the underlying interplays that exist between the parties. You need, as a mediator, to prepare yourself for what you're about to engage in so that you can be meaningfully responsive to what is happening in front of you. Even without a risk dynamic, you need to know what's going on. When there is a risk dynamic, you've got to add another layer of competence and diligence and stamina and curiosity and judgment suspension and all those things that make for a good mediator. In the absence of an intake, you cannot possibly deliver on that. So from my perspective, the intake does two things. It builds rapport with the individual one-on-one without them wondering who's in the other room or who is in the room. Yeah. Completely different mindset, and it prepares you and it allows you to begin to build your case theory. There's some fabulous studies in neuroscience that show that if you're asking someone to begin to shift perspectives, it takes between 7 and 14 days after you've sowed that seed for them to be able to even begin to think differently. So from my perspective, intakes should be done a week out. You want to be testing the waters and potentially forming your own case theory about reflective parental capacity, which might mean you need to ask some slightly difficult questions of the person you're meeting with, but not so difficult that you've tipped them over the edge before you even enter into the mediation process itself. So it's absolutely crucial for you, and it's absolutely crucial for the parties. And then, of course, you must do something with that information between when you learned it and when you turn up on the day to start the discussions. Absolutely. Knowing that what you might have stirred up in the person you're asking those questions might be far more than you're aware of at that stage.
And I think that's where that really great rapport comes in, because I think if you have started to build at least that rapport with your clients, whether it is not everybody's happy with the words, but I'm going to use the standards, the perpetrator or the victim. And I think even building that rapport with the perpetrator so that way you have an understanding of, I guess, their baseline. You have an understanding of how far you can go in a mediation, where are their limits, that you can have a genuine, honest conversation with them that is safe enough for everybody, and with the victim for them to be able to feel supported in the mediation, for them to be able to have a voice and all of those things. So I think that that rapport building is so important at intake, and that is something that I think can't be rushed.
And I think the content of the mediation is immaterial. It doesn't matter what you're going to be talking about in substance. When I was in private practice, I would do intakes in my sports mediations, in my franchising tribunal work, in my wills and estates, in family law, without fail. Otherwise, what are you there for? If you're not actually bringing something to meaningfully and strategically assist the negotiation, then everyone is just giving you to wander through blindly. The other thing I think about intake is that it allows you to really draw on some sophisticated skills. And if we looked at those matters that come before the court, if we said, if you've got a risk factor, we won't mediate, then 91% of our matters are going straight to trial. And that's one of the reasons why, prior to the new case management pathway in the FCFCOA in September 2021, we had such significant delays in getting to trial. There was no sophisticated approach to dispute resolution. What we've done then as a cohort amongst registrars and the judges, but the registrars is where my energies go, is learn as much as we possibly can about the dynamics of family violence and when parties are able and comfortable to raise those issues. So we're looking for the clues that would say, yes, now it is safe and productive to negotiate, or now, or not yet, and therefore we need to take these additional steps. Dispute resolution is not an event. It's not the thing you do on the day you show up for mediation. It's a process, and it's the responsibility of everyone who works in this space. And the responsibility of the family law system as a whole is to say to victims, survivors of family violence, you've got an alternative to a litigated outcome. We will not say this is too hard. We will say, how can we do this safely and productively? What do we need to do to help you move through? It's not the responsibility of the victim survivor to turn into something that they are not able to be or not able to contribute. It's the professional's job to improve their equilibrium to the extent that they can make decisions.
Absolutely. And with that, we need professionals who have that, I guess, that understanding, that capacity to be able to work not just by themselves, but also with others within the industry, to work people through that process. Which I think it's so interesting. I loved when the court brought in the post-filing mediation. And I know myself doing pre-filing and post-filing cases, they're very different, and people at a very different stages. But I think, and that's that process that you're talking about, is that they have worked their way through certain stages, and so many people, really great professionals, have kind of influenced along the way, which has sort of set them up to hopefully that best possibility.
And in many respects, those post-filing matters give you a lot more to work with, because nothing's superficial anymore. The once you cross the threshold of the court, you've had to articulate, albeit in a legalistic, unnatural way, the big issues that are creating the conflict in your life. You've had to put it out there. You've had to say, this is the behaviour that I've been experiencing. This is the information I've been denied. This is the dynamic that I'm exposed to, in a way that gives the mediator much more to work with, to say, okay, well, we might not be able to solve the whole thing within 15 minutes, but is there something else at the sides that I can work with?
Yeah.
I think that deeply understanding family violence is so crucial. There are so many great resources, there are so many great trainers, but I think the thing that really transformed my confidence about how to work in this space is the training that the court invested in with David Mandel from the Safe and Together Institute. And the thing that really shifted for me is that what you have to be able to do is engage with the alleged perpetrator as much as you engage with the victim, because a mediation is not about getting the victim's say across the line. It's about helping the parties meaningfully negotiate an outcome that they'll commit to.
Yeah.
And if you've alienated the perpetrator along the way, your agreement's got no stickability. There's no point to it. And so what the Safe and Together training talks about is patterns of behaviour, things, not single incidents of really high risk behaviour, but patterns of behaviour that give you a clue about the dynamic that exists in this relationship, so that might seem inconsequential to you because taking the car keys only happened once. But when you combine that with failing to make sure that a child with an anaphylactic reaction avoids peanuts, and you combine that with not providing enough funds to buy warm clothes in winter, there's a pattern of behaviour then that allows you to say, there's instability being created here in different ways all the time. We call that, as a concept, multiple pathways to harm. There might be lots of things that are happening there that could then happen in the way the negotiation pans out, that's really coded and meaningful between the parties, but easy to miss for the mediator. And then the other thing that the Safe and Together training talks about is this idea that control or abuse of a partner is a parenting choice. It's a decision that the perpetrator makes to behave poorly towards the other parent. And both parents should be held to the same standard. Fathers should behave and prioritise their children's welfare in the same way that mothers are always expected to behave and prioritise their children's welfare, regardless of who's behaving badly, who's perpetrating the alleged violence. It's a decision to undermine the functioning of the other parent. And when you start thinking like that, then you can listen to a proposal. We've all been in these situations where you get a proposal from someone and you think, to yourself, please do not put that on the table. I can tell that is going to be so helpful, so unhelpful.
Yeah.
That you're able to dig a bit deeper and to say, tell me a bit more about that. How might that be received? Have you, the person who's trying to push some buttons here, got any capacity to rein that back in? And sometimes you discover that they do. Yeah. And I love that moment where you've formed a view in your intake and you try really hard not to form any views about anything, but you think, this is the rigid thinker, this is the one I'm going to have to work hard with. And they make the first concession.
Yeah.
And you think, oh, good on you. I didn't see that coming. That is great. You can't do that without the intake.
Yeah.
You can't begin to really prepare deeply for what you're about to face unless you've thought about so many things.
Absolutely. And I think that falls into, there's a question there around pre-mediation conflict coaching with clients individually. And I don't know what your thoughts are about that, Anne-Marie.
I think it depends on what the conflict coaching is. I think coaching someone to cope with conflict and to sit in a dynamic where you're being asked to negotiate when you're having a cortisol flood and you've flipped your lid and your amygdala hijack is in full flight. I think coaching someone to manage that is absolutely crucial. No one should be going into a mediation so dialed up they can't hear a word anyone says. But conflict coaching to the point where you're unable to get to the issues, where a party is saying all the right things and giving all the right indications and not digging deep enough within their own contribution to the dynamic to say, oh, that behaviour might need to change or that concession might be a good one to make, I think is where it gets a little trickier. So I think it depends very much on the type of coaching.
Yeah,
because the purpose of the mediation is to make all the professionals involved in this family's life redundant. Get out of there so that these two people can move forward in a way that's going to work for them. Yeah. And if it's a try-on, if it's a structure, it's all going to fall apart. Yeah. And that's a disservice. Yeah. And that might create greater risk.
And it was quite interesting. I was speaking to a Brisbane lawyer the other day, and he said to me, he's got a client who needed FDR, and he goes, honestly, Bobbi, I can't remember the last time I actually went to an FDR session. He goes, what the hell would I know? These people are the experts on their kids. I can talk to them about the law. I can prepare them for all of that. He goes, but that's where you come in. That's your level of expertise about pulling out their expertise. He goes, I'm there to help with the law part. He goes, but other than that, these people know their kids. And it's about pulling out the best in each of those parties and coaching them so that way they know what that looks like from their perspective and how they're going to go about doing it.
Such a crucial observation you just made there, Bobbi. It's about bringing out the best.
Yeah.
Everyone has more to contribute to resolution and improving the dynamic than the family law system allows them to focus on. It's the nature of an adversarial system, and we can't change that system. But what we can do is say, okay, so you've got some fundamental challenges. There are risks here. There is significant disagreement. Someone wants to relocate. Everything's at stake. You feel at sea. But that doesn't mean there's nothing to work with. Yeah. And it doesn't mean we can't be optimistic about the idea of moving forward. It's not about happiness. It's about positive problem solving, saying, all right, what have we got that is working? And again, we know from all the studies in neuroscience that little yeses lead to bigger yeses. Mm-hmm. And that's one of the great things about mediating, isn't it? You start the day thinking, oh my goodness, where am I going to find the thing that's going to allow me to move? And when I'm doing all my training, I say to the students, you just have to have Leonard Cohen in your head. Ring the bell that still can ring. There is a crack in everything. That's how the light gets in.
Yeah.
And all you're doing is just looking for that first thing. And sometimes it closes off. And you say, all right, I'll have to try over here.
Yeah. And again, I think going back to intake, that gives you that opportunity to have that level of understanding of your clients. That gives you the first clue so that you can actually work that through in the mediation. Yeah.
Yeah.
There's a lot of wonderful comments coming through. Anne-Marie, can we talk a little bit around, as practitioners, how we don't create risk? Because obviously when we're dealing with domestic violence, we've got people who are at risk. Have you got any thoughts on how, as practitioners, we don't escalate things where we're actually making people unsafe or even ourselves unsafe?
Yeah, there's a few things there. The first thing is you cannot safely read risk and manage risk for other people if you don't come from a place of deep equilibrium. If you are rattled, if you are unsettled in your life, your ability to provide a safe, calm, consistent environment for other people is compromised. Other people's conflict makes us feel rattled. We've all had it. I'm sure you've all had those matters where you just need to go home and have a shower. It has been so hard and so difficult. That's very, very real. And I think one of the challenges of working in mediation is the debriefing opportunities that are just so crucial for doing this work are so few and far between, because you're essentially in competition with your fellow mediators, and it's very difficult to find a network sometimes that allows you to say, jeepers, that one really got to me. Something was happening to me in that moment. And so I'm a real believer that that's where mediation will evolve to. We will have a much more sophisticated way of engaging in our own self-care. I think training in relation to trauma-informed practice is also really important then. So not only are you knowing what's happening what's a trauma response, but also where vicarious trauma starts to creep in and affect you. So first of all, you have to be the port in the storm, and you have to be able to let the storm go on around you. If you can't do that, it's going to be much, much harder for you to do the job. It's then about, there's risk in two ways I think about it when you're mediating. One is the disclosed risk, the dynamic that you know about, that you're cognizant of, and you're trying to manage and carefully and deftly negotiate. And one of the best ways to do that is to shuttle until you're comfortable that not shuttling is going to be productive. And if in doubt, shuttle. Go through that process until you are satisfied with the answer that you've been given from the individual who says, yes, I can sit in the room. Have a real suite of questions about how, often the question we ask is, how comfortable are you being in the same room? That's a very different question to what would it be like for you to respond to a proposal that's made you a bit anxious in the moment? What would be your what sort of time frame would you like to have before you considered a proposal that's got multiple components? Because that's what's going to happen when everyone's in the room. It's going to be coming thick and fast. And if all that individual is thinking about is, yeah, I could be physically near them, and they're saying, yeah, I could do it, that's a big no. Unless you're getting a, yes, I could think deeply, I'd need to take some notes, and I probably need a few minutes, but yes, I could do it. You've got an environment where you are going to very quickly exhaust the capacity of the parties, those who need to be able to make decisions, because we all know what the capacity for memory recall, for positive problem solving is when you're highly stressed and your amygdala's taking over. So there's that physical component, so making sure that you're not creating risk in the sense of an inability to meaningfully negotiate. And then the other is the risk that is being generated by asking these questions, by challenging positions, by being the person who is saying to someone who's being at best obstructionist, at worst downright dangerous, how are you contributing to this? What is your contribution to this dynamic? And what you have to be very mindful of there then is, what's going to happen if we don't get to an agreement here? What's going to happen if I've been the one who's pushed and pushed and pushed, couldn't get them to compromise, they look a bit annoyed, they've had a tough day, they leave you, and they take out those frustrations on the other party to the mediation, or on the children, or in their workplace. What is the risk that might transpire because someone has been agitated through this process?
Yeah.
Sometimes that risk exists when you've got to closure. Allowing someone to have their expectations adjusted with dignity is the great gift of mediation. Creating enough time for someone who's come in asking for this when everyone is thinking it's never going to happen, to settle here, is brutal in any forum other than a mediation. Be cognizant of that. Acknowledge it. Make sure that person knows that they've done that, they've had that experience, and without revealing anything you can't from the confidential setting, most parties know. Most of the people on the other side know that's been a big day.
Yeah.
And I always talk about that. What's next? When are you two next going to see each other? And I especially talk about this if there hasn't been an agreement. But how do we need to wrap it up today so that you can move productively forward? And it's not all systems go once you get out of here, but we're holding everyone as far as possible to the agreement that might have been reached or almost reached. There's a new video on the court's website. It's not so new anymore. It's a 2021 video where we really changed the language on the website. Initially, the plan was we can agree, therefore go into consent orders. We can't agree, therefore go into the litigation part. And one of the observations I made was lots of people can agree on some things, and we don't want to throw that baby out with the bathwater. We want to say, stay there. If that's what you can agree on, don't go right back to pistols at dawn. Recognise there's things that you can agree, and let's grow from there.
Absolutely. And a lot of that, of what you've just been talking about, is about our language and how we present ourselves in a mediation. And as you were talking, I was thinking about, those reframing skills, those normalizing, that, ensuring that somebody, walks out of a mediation with dignity, that they present themselves in a mediation, with dignity and grace, and allowing that opportunity. And we do that. We are the powerful ones in the room that can provide that to clients. And I think it's so important because that helps to even out that power dynamic and keep people safe, both during and post.
And I think, Bobbi, that comes back again to a skilled intake.
Yeah.
And I'd really encourage everyone to think really deeply about the questions you ask in an intake and why you're asking them. Because if what you're trying to assess is, have I got someone who is capable of being vulnerable, who's got a level of humility or hubris that they can bring to this table, that they're capable of looking through the lens of the other parent, or have I got someone for all sorts of different reasons can't do that or won't do that or not yet, and I'm going to need to chip away a bit more? Because if you've got someone who is about to lose, in their mind, everything that's dear to them, in terms of how much time they think that spending with their children is going to influence the kind of parent that their child's going to view them to be, that's an incredibly vulnerable place. Can that person go there? Is it too much for them to go there? In which case, what are you going to do with that?
Yeah. And even that level of vulnerability, I can only imagine what that would be like as a non-perpetrator, and what that feeling would be like, let alone being somebody who behaves in ways that are inappropriate and uses that as a way of utilizing their power. That level of vulnerability.
There's two really good questions that have just come in the chat that I do want to get to. My biggest fear, everyone, is Bobbi and I are just going to talk and have a great time, and we won't cover your questions. One was about trauma-informed practice. Trauma-informed practice is really training that invites you to think about the experience that the other person might have had in their lives that might have been traumatic for them, that then triggers a response that's emotionally disproportionate, that's overwhelming, that exceeds their capacity to self-regulate. That then informs the way that they conduct themselves in conflict, the way that they prepare their court material. So understanding that what you might be seeing might be a person who's enormously aggressive or scattered or difficult, might just be their way of coping with the trauma that has infused their life up until that point. It's essentially about being curious and sympathetic and respectful of the individual who's right in front of you and saying, what else might be going on for them right now? Vicarious trauma is the impact that dealing with other people's conflict and trauma has on you. It's inevitable. Over time, things get to you. Some matters are worse than others. Some matters stick with you longer than others. So trauma-informed training allows you to be more aware about what you're watching and is unfolding in front of you, and to manage your own responses and needs in relation to that. There's a lot of organisations that offer that kind of training. Blue Knot is one of them, but there's plenty. There's lots of books about it as well, lots of podcasts. The other question that just came through, I saw from Barry Berger, hello Barry, is about length of mediations. Look, I think it depends. And I think one of the challenges about how private mediations work is you don't have as much opportunity as we now have in the courts in some ways to think about what's needed when you have a booking, you say this is where we're coming to. I am a big believer in some cases shorter and more is better, but the trick with shorter and more is holding everyone to the point where they were at the end of that first session, and that's real mediator skill, setting everyone up so you don't go 3 steps backwards when you come back the next time. I think that there is great, and it's going to sound slightly contradictory, there is great power in the closing of the window of the event coming to an end, of everyone really having to focus and make difficult decisions, because the decisions themselves don't get any easier just because you spend more time talking about them. Coping with the dynamic, and particularly in a risk dynamic, shorter bursts of having to stay in that place can be better for cognitive functioning of the parties. But the idea that you've got a closing window of opportunity to come to a decision can be really powerful, because there's always a next if there's no agreement. In the post-filing world, the next is going to be moving to trial. It's going to be turning that big, ugly corner in the court system and heading towards a judge. And if you're in a pre-filing context, the next is turning that big, ugly corner and going to the court. Choosing not coming to an agreement is choosing a non-agreement. And I think parties underestimate the extent to which they can actually change that dynamic. And the reasons for making that choice are many and varied. You couldn't possibly say it's just because of X. But I think a really skilled mediator who's tenacious but not pushy is able to say, whatever you do now is a choice. And there are consequences for your choice. And I always say to parties, you need to leave today, this process, knowing that you have nothing left in the tank, that there is nothing more that you could do, so that when you're sitting in court before a judge and you're hearing your life analysed through this narrow legalistic lens, you're not sitting there saying, could this have been avoided? Could I have done something else? Could I just have agreed to something? You want to know that the answer to that question, which you will ask yourself because it's a hard road ahead, is no. I could not have done any more. And then there's a sense of peace about that. I had to take this course. I couldn't have prevented it. If you don't have that really deep, thoughtful discussion about next, then, you're working with far less tools than you've really got in your toolbox as a mediator.
Absolutely. And I think from a DV perspective as well, people knowing that they have those choices, because often when there's domestic and family violence, people don't know that they have a choice, or they're not used to having a choice. So they don't always know how to actually use that in such a way where they do have an element of peace with it. And I think that's really important to think about as well. I use the word choice in mine all the time too.
Yes. And I think people are sometimes surprised by the choice they're capable of making.
Yeah.
They just haven't been able to put all those pieces together in a way that allows them to say, I could live with that.
Yeah.
Now that I'm seeing what this compromise looks like compared to what lies on the other side, it is the lesser of two evils.
Yeah.
And, I'm sure we've all had that thought. No one leaves a mediation happy. Everyone leaves prepared to live with the outcome. Yeah.
Yeah.
And I think that's the ways that you can get to that is really multi-dimensional. And this is the great beauty of being a mediator. Humans are fantastic. They're fascinating. They're capable of doing things that I don't do and think about and unlock if you just give them the chance and the wherewithal to begin to think about it, to look for it. And I think a lot of that is hard for legal reps, and I'm not critical of lawyers. I mean, some lawyers are just gladiators who make everyone's job much harder. But the way lawyers are trained is very particular. It's very infused in binary thinking, and it's focused on risk, and it's focused on minimising opportunities to be wrong. And so that creates very rigid ways of thinking for parties, and you spend months and months and months with your lawyer, and your lawyer asks you consistent questions about these things, and so your capacity to negotiate is much harder when you've been trying to think through that legal prism.
Yeah.
And the thing about a mediator, and this is why I love the post-filing, is you can say to the parties and the lawyers, you can just park all that for now. Let's see what's really happening here. What's motivating you? And my experience, by and large, has been lawyers are excellent problem solvers. If you say to them, just let's not forget, we don't have to worry about that here. If we can't get to closure today, we're going to have to talk about that stuff. But let's just forget about it. What do you reckon's happening? What might be the choices? What might be the other options? What are the things we haven't asked about?
I love when the lawyers use the words for the purpose of mediation. So that way they can think creatively, because otherwise, if they don't say that first up, they can't get that level of creativity. So the first
just in case I'm in the 10% of cases that might actually meet a judge, I better behave like that in my other 90% as well.
Exactly. So they go, oh, just for the purposes of mediation, I'll be creative.
Yeah, I'll encourage my client to make some
Exactly.
concessions and think about their contribution to closure.
That's right. And then straight away, I'm like, that's okay. The rest of the day, let's just put it down to for the purpose of mediation. So we don't need to talk about that again. That's what we're here for. But it is, mediation is a choice and an opportunity. And I think when people realize that, it opens up all these doors that they just hadn't even thought about.
Again, the power of the intake. It's your opportunity as the mediator to assess for yourself how ready for negotiation, not necessarily compromise at that early stage, but negotiation that person really is. Because the lawyer will say, yeah, we've booked it, we're ready. But if the individual hasn't started to really think about what they might need to do in the moment, what they might feel really confronted by being asked to do, I ask lots of questions about the human beings that have nothing to do with any of the issues anyone's told me about.
Yeah.
Because all I want to do is build my case theory about this individual and find the things that I can genuinely connect with them about. And there's always something.
Yeah, it's
People
interesting.
Are fantastic.
Whenever I'm training, I'm always talking about, no matter what, the very first thing you must do and you must continue to do is connect with the human. It's all about connecting with the human. If you can do that in a mediation, your clients will have so much more success. It's not about everything else. It's about connecting with the human. That's what makes everything.
Some make that easier than others.
True, absolutely. But even the ones that make it difficult, I think for me personally, that becomes a bit of a challenge and almost this is going to come across wrong. I don't want it to come across this way, but it's almost like a game in my head where I'm like, okay, I'm going to find a way to connect with you.
I think the people who are hard to connect with have a lot to give.
Yeah.
Once you can forge that connection.
Yeah. And it's so powerful when you do. And it's one of I think the most challenging times in a mediation, but it's also one of the most beautiful things that you can ever do as well, is allow them then to connect and have opportunity and choice in a mediation too, I think is brilliant. There's a question there around circumstances around when you would have clients in a joint setting, and I guess specifically to domestic violence cases. How do you feel about shuttle versus joint?
So I think that's a really individual answer, and you need to know as much as you possibly can about the matter. So in a private mediation setting, if it's a pre-filing matter, so you don't have the benefit of any court material, you've got to go right back to working out how you're going to find out what the underlying dynamic is. So when once you've crossed, one good thing about crossing the threshold of the court is you get an affidavit, you get a notice of risk, you've got a requirement to file any existing orders. So you've got your hook for saying, tell me a bit more about that. That's a little note in my mind, there might be an element of risk here. If it's a private matter, you want to work out how you're going to ask those questions. Am I going to get a copy of the family violence order? Is it an order that's been made on a without admissions basis? What does that tell me really about what might be the dynamic here? So working out what have I got to work with. Then asking those questions in the intake, what's their capacity to be present with the other person and have the dialogue. Frequently, if you're getting a yes that you're comfortable with and confident about, that yes, I could be in the same room, but I don't want to say anything, I will do a joint opening so that everyone is crystal clear that they've heard exactly the same thing from me about my expectations about what's about to happen, how I'm going to manage the day. So this is you just saying to everyone, nothing you have told me bothers me at all. I know what I'm doing here. My eyes are wide open. This is how it's going to work. Controlling the process, not controlling the outcome. I'm then watching really carefully, and you can do that whether you're online or in person. I'm watching really carefully what's happening in the bodies of the people who I'm working with. If it's face to face, I absolutely will set up the room so they cannot see each other out of the corner of their eye. If I've got legal reps, they go in the middle. I've talked to the parties about how we're coming into that room together. Who's going to be there first? What's going to happen? How's that little awkwardness going to work? And then it's just all eyes on me and me delivering. And particularly for an FDRP, you've got to discharge all of those obligations really comprehensively, talking about confidentiality and you not imposing an outcome, talking about the opportunity that exists. Setting it up so that when you finish talking, everyone is feeling, I can do this. I'm going to make the first good move. Whether or not you let the parties actually start to do that depends on who you're working with. Have you got someone who isn't going to be able to either speak or listen productively, in which case you simply break it off. But you've prepped everyone for that. You've said to them in the, so there's a part before, after intake and before the mediation starts, of course, because you can't meet two people simultaneously at once unless they're all standing in the same place. So you're going to have a moment with everyone. I make it as long as it takes, so that you can be satisfied that the person who's turned up that day is the person who you met on the phone, because that changes, right? People turn up, and when they're actually there and they're about to talk, they become they get a very different level of comfort. So who have I really got here? Do I want to put these people together? And if you don't, if you're deciding to shuttle, what are you going to tell them about why you've made that decision? Prepare them for that in the intake, because of course you're not going into the room and saying to party B, oh my goodness, party A is a bit of a basket case this morning. I think it's going to be better if I just shuttle now. No, I've got a whole lot of things I have to tell the two of you. You want to be duck under the water. I was fully expecting this. Actually, I wasn't expecting this, but it happens from time to time. So now I'm going to have to do my discharge of my responsibilities across two rooms and make sure everyone knows I'm saying exactly the same here as what I'm saying here. And then I never decide what's going to happen in terms of shuttling or not shuttling. I just do it.
Wing it.
Sometimes you shuttle all day. No, you don't wing it, Bobbi. You know that. It's so much more sophisticated than winging it, everyone. You are thinking about it all the time. What just happened in that room? What am I doing now? Why am I doing it now? Is it going to be helpful? I think when you've done it for a long time, you don't have to think about it. But I can think really clearly in my early days, just constantly saying to myself,
what am I doing?
What next? What next?
And
Where do
why?
I go next? That was really aggressive. That didn't sound like a compromise. I don't think I've got anything in here. That person's been in the other room for 45 minutes. What next? What next?
I think what you said then, Anne-Marie, was another thing that I think was really, really important, especially when we're looking at whether we're doing joint or shuttle. In a shuttle, I've found, especially with domestic violence cases, that people will often make assumptions about what's going on in the other room. And I think what you said was, is the person that turns up on the day the same as the person that you've spoken to before? And will the clients make a clear understanding of what's going on? And I think by providing that joint session, at least if it's just your opening statement at the beginning, everybody can then see that you are who you are and you're exactly the same with both clients.
So
not being different.
Crucial.
And I think especially when there's that power dynamic with domestic violence, you know, I have no doubt that the clients are sitting there going, what's going on in the other room? Is the perpetrator charming the mediator? You know, was the mediator different to that person? You know, the perpetrator thinking, you know, are they colluding against me? You know, all of these assumptions can be made. And I think having that opportunity for the clients to see you with both of them is a real opportunity again to put
so crucial for cementing your role, your control. I hate to use that word, but it's very
process control.
It's very important. You're in control of the process. You don't waver for each of them. Of course, you're building rapport differently with different people. If you don't, you're not building rapport. Right. But what you are doing when you're talking about the process is crystal clear and consistent. The other thing about solely shuttling is the power of invisibility, and not in a good way. That a person who is never seen during the course of a negotiation becomes a position rather than a human being who has something to contribute to the dynamic, who has needs that have either been met or unmet. So I often talk to parties about, again, in the intake, and let them think about it, and I tell them, I'm going to ask you again when we get together, what would it be like if she never saw you? How might that affect her thinking about you? Would it be helpful if just for a moment while we were all together, you were physically present in the room. Because that's a bit of a sign of a commitment to your kids, isn't it? And to you're here for a reason. And sometimes I find that can be really helpful in everyone experiencing the commitment of each party to be here to negotiate. So think about, one of my favourite Zen proverbs, nothing is nothing. Whatever you do, however you set it up, whatever step you take has an impact. And you want to be thinking about it. I just chuckle because mediation is not easy. Anyone who thinks that it's a doddle after a life in litigation, if they're going to be a good mediator, I think is in for a shock. There was a question that came in the context of shorter mediations and processes.
Quite a few comments on that, yeah.
Yeah, so I very strongly believe we are on the cusp of great change in mediation. We've done mediation in a certain way, a single day, everyone leading to this, position statements. God, do not ask people for position statements. And if you're getting them, prepare the client for them. I tell the client, don't read it. It's for me. I've come down with the last shower. It's to catch me up. It's likely to contain all the things you disagree with. You know that. I know that. Don't worry about it. They are so unhelpful. So all of that, I think, we are on the cusp of an enormous shift. That we're saying that's how we needed to do it when legal thinkers started to turn that ocean liner around and say, we can look at conflict differently. We can start to resolve this without litigated combat. And now we're moving to a level of sophistication that I think opens extraordinary opportunities for people to think about what it means to be a dispute resolutionist. So there is a resolution revolution in train. Yeah. And when that is led by the court, when the court says we have got to do things differently, we are not taking a pathway to trial because we'll never be able to service the trial and it is so damaging for Australian families, then every lawyer and everyone working in the family law system is pulling in the same direction and saying, okay, what does this family need with its particular dynamics? Is this a let's all just do the numbers, come together for half a day, horse trade, get out of here? Or do we need some expert assistance in terms of medical assessments, evaluations, so that there is really enough here on the table to meaningfully negotiate? And are these people capable of doing that in a day? It's a process. It's not a single event. And I think we're really going to see sophisticated models developing in ways that are enormously rewarding for families and for the practitioners who work in it.
And I think there's a great comment in there from, I think it's Beth, around how many is too many, and with that, when are people using coercive control to actually manipulate the process and continue with their domestic violence?
Yeah. So the definition of insanity, doing the same thing over and over again, hoping for a different result.
Yeah.
So when we're in the court system, we're looking very carefully and asking lots of questions about, well, what have you tried? If you need to come here, what have you done before? Because we're not going to repeat that and make you spend your money to go through the same dance that's going to lead to this point. Is it a lack of information? Is it a need for some expert intervention? Is it someone who is being manipulative and engaging in coercive control, or once they've filed, systems abuse? You need to be really skilled at assessing what the dynamic is. And if you haven't worked it out, 11 mediations, I would say that is too many. One of the most powerful questions you can ask of both parties is, it's really interesting to me, you've been working really hard, but we haven't quite got there. What do you think's going on? And then you're going to get an answer that's completely deflective. They are not doing, they won't, they tells you a whole lot about that person. Or you might get an answer that says, I think I just need this more piece of information, or I need to actually surrender, make peace with, accept various things. It leads to a completely different discussion. Don't work harder than the parties. It's their conflict to resolve. You're there to guide it.
I had one not long ago, and they'd been to a lot of mediations, ended up in the court process, but I think they'd done at least a half a dozen before they got to the post-filing. And when the client left the session, he actually said to me, I don't know what to do now, Bobbi. This has been my hobby. Like this, this has literally been my hobby for the last 5 years.
I've done all I talk to my new partner about. Our relationship is founded on the common enemy.
Correct. And he goes, I just don't know. And I went, maybe try golf. And he goes, okay. But he honestly, he was so lost. The conflict had consumed him. And when we spoke about it, part of the reason he thought that it hadn't been resolved was because of the fact that he didn't know where to after that.
That's insightful, isn't it?
Part of him. Thankfully, this case didn't have high levels of domestic violence or anything in it. So there was really good insight from the clients a lot of the time. But yeah, for him,
and sometimes, and this is the major transformation in the courts. Sometimes it's the filing that changes things. It's the commitment that the applicant shows to wanting to get to closure, to needing that piece of information, to being committed to a parenting role, that the respondent needs to see and hear and to say, oh, I am going to have to pay attention to this. This is real. This is not going away. And then what the registrars are able to do that judges cannot, because they can't have the same kind of conversations, is help that person get to the point where they can meaningfully negotiate. And those who won't, those who are withholding, abusive, unable to safely negotiate, they're going to move to the judges faster.
Absolutely. Now, we're just almost out of time. So, Anne-Marie, one more question, and it kind of falls into just some slides I want to show about where to from here. What are your views on mandated domestic violence training for those in the legal profession?
Oh, it's absolutely crucial. We talk about optional, but those of you who follow very closely what the Attorney General's Department is doing, coercive control, is very much the focus of the AGD's training. You'll hear much more about that. I would start investing in it now. You cannot do too much. The more you learn, the more you put your head in your hands and say, oh my goodness, this is so big.
Absolutely. And with that, we've actually put together some training for mediators. We're going to start it next year, which is about working with domestic violence. So we've put our heads together, just knowing that we often see it in training. So many lawyers, specifically lawyers, will say, we didn't learn this. Like, I need to know more. I thought I knew, but I don't have enough. The training itself starts to get them to think a little bit differently, but there's still that gap. So what I've done is I have got a link. Just give me half a moment. And what you can do, we haven't worked out what the dates are or anything yet, but we're looking at possibly February or March. Let me press enter. Oh, hang on. I think I just shared that with you and I, Anne-Marie. Give me a moment. Let me try one more time. If you would like, you can do a sort of a pre-registration for some training on working with domestic violence in mediation. So if you would like to, we can then keep you up to date with dates and things as it starts to come out later in the year. Now, just before we finish off as well, I just want to just let everybody know sort of where we're at with the rest of the year. So we do have coming up our next lot of NAMAS training, which is it's a 6-day training. And as everybody's aware, there's going to be really big changes with the Mediator Standards Board and the accreditation, and there's going to be levels now. So if you want to get on board and kind of use your time effectively, because to get to level 2, you're going to need at least 2 years experience, or at least 2 years qualified as a NAMAS mediator. So it's probably the good time. It's the last one for the year. So if anyone's interested, we do have that. I've also got a 2-day property mediation class coming up, masterclass, and we've also got an evaluative mediation masterclass that we do as well, and that'll be at the end of November. Our memberships for next year will also be released soon as well. So please take a look at those if that's something that's interesting to you. The other things that we also offer, and it kind of falls into, Anne-Marie, some of the things that we were talking about before around that self-care for practitioners and making sure that we do have, I guess, that support that we need, because it is very isolated, some of the work that we do. So we do offer supervision as well. We also offer template packages, and we've also put together a demonstration of an intake for family mediation, one for workplace, and there's also a demonstration of a family mediation matter. I'm the lucky mediator in all of those. So if they do interest you, please let us know, and we can provide you with those as well. And there's the training that's coming up next year around the working with domestic violence. Thank you, everybody, for your questions. But most of all, Anne-Marie, thank you so much. You are a wealth of knowledge, and everyone just loves listening to everything that you talk about. You're so experienced.
Except my children.
Oh, well, they're not supposed to be in awe of you, only us. But thank you so much. We appreciate everything that you do, and we love the fact that you're one of those change makers that is happening in our industry, and you have been right from the beginning. So we really look forward to what's happening next, and we look forward to all supporting you as practitioners with the change that is about to happen.
Thank you, Bobbi. Thanks, everyone. Have a good afternoon.
Thank you. Bye.